Welcome to County Court Weekday Update.
I'm your host, Judge Elizabeth Brodsky, presiding County Court Judge for the 20th Judicial District.
And I'm your co-host, Lila Soul, attorney at Colorado Legal Services.
Today, our focus is civil protection orders. It is your first day serving as a county court judge. You reviewed your docket, prepared for each individual case, and you survived the morning. It's 11:55 a.m., and you're thinking about lunch. Your clerk rushes into your office and informs you that you are needed in the courtroom to hold a civil temporary protection order hearing. What? This wasn't on your docket? You have a vague recollection of hearing that there exists such a thing, but you don't even know the applicable statute.
You can do this, and we're here to help.
Today, we will give you all of the tools you need to handle civil protection orders, from the first ex parte temporary protection order proceeding to the permanent protection order hearing and any subsequent modifications. We developed outlines encompassing the entire statutory framework and our top 10 complex civil protection order issues. These detailed outlines can be found in the County Court Civil Protection Order Judicial Reference Manual on the judicial website. It is designed for you to use on the bench, and if used electronically, it hyperlinks to Westlaw.
Also included in the materials are several bench card cheat sheets to keep at your fingertips. The applicable statutes are Colorado Revised Statutes 1314-100.2 et seq.
Okay. So you're back in your chambers and your clerk hands you the protection order paperwork. The complaint looks like this. You should conduct a review of the complaint to make a preliminary assessment of venue and subject matter jurisdiction.
The outline accompanying this video provides a list of individuals who can be protected parties and who can be named as restrained parties. Sometimes at this stage, the issue of standing will arise. This brings us to number 10 of the civil protection order issues, standing to seek a protection order on behalf of another. Most commonly, this arises when one parent requests a protection order on behalf of a child. It is critical to ascertain whether the parent has the legal authority to do so by inquiry and conducting that statewide search on Eclipse.
Another issue involving children arises when one parent seeks to prohibit the other parent from having contact with their shared child. This brings us to the 8th and 9th top 10 civil protection order issues, the intersection of county court, district court, and juvenile court, and constitutional issues regarding children as protected parties. The court must inquire about the existence of any prior protection orders. If there is an existing district court family law case involving the same parties, the temporary protection order will likely be filed in the district court. The county court cannot make orders regarding children under this statute if there is an active dependency and neglect case. When the protected party requests that the restrained party be prohibited from having contact with their shared child, it raises constitutional issues that you must consider.
Children can be included as the actual protected persons in the protection order, or they can be addressed in the care and control provisions of the protection order. One of the main legal concerns is the constitutional issue. Under the 14th Amendment of our Constitution, parents have a fundamental liberty interest in the care, custody, and control of their children. Judges need to ensure that they're not violating the 14th Amendment if they add a child as a protected party for a permanent protection order. There are evidentiary situations where adding a child as a protected person is totally appropriate. What I encourage judges to do is to make detailed findings of why this particular parent is an ongoing threat of harm to the child. My former law clerk and I wrote an article and made a presentation on the topic. Those materials are included in the handouts for this training.
After assessing venue, jurisdiction, and standing, you will go into the courtroom and take sworn testimony from the petitioner. The petitioner bears the burden of proof by a preponderance of the evidence that an imminent danger exists to the person or persons seeking that order.
The vast majority of petitioners at this stage of the proceeding are self-represented. This brings us to the 7th of the top 10 complex civil protection order issues: access to justice.
Often, those appearing before you for a protection order are in crisis. You're encouraged to be aware of the resources in your community, to include legal services, human services, and of course, protective services.
It is a good idea to have a list of open-ended questions to ask the litigant to ensure that their voice is heard. Rule 2.2, Comment 4 of our Code of Judicial Conduct allows for us to do this.
If the burden is met, you will issue the temporary protection order and set a return date for the permanent protection order within 14 days. If the petitioner is a victim of domestic violence or sexual assault, enter an order waiving that service of process fee.
You may want to use a checklist the judge fills out with the information the clerk will need to input into Eclipse. This checklist is included in the materials.
Ladies and gentlemen, this brings us to the 6th of the top 10 complex civil protection order issues: the practical issue of data entry, which directly relates to your enforcement of the order.
All right, then, the protection order is granted.
Your Honor, pursuant to testimony, my client is requesting the following exceptions in order to accommodate parenting time.
Ms. Soul, I'm aware of how detailed you can be, so let me stop you right there. Aubrey, can you please explain the character limitations?
Judges need to be aware that elaborate orders regarding restrictions or other details simply aren't possible. Deputy Bach, can you explain why this is important?
Well, the information entered in the system feeds into a centralized database that law enforcement is able to access in the field. This allows the quick and efficient enforcement of the issued protection orders. Only the information entered into the database can be viewed by law enforcement. Therefore, it is critical that all orders are conveyed into the database in accordance with the character limit. Protection orders can only be properly enforced in the field if you comply with these restrictions.
In order to meet these requirements, you may want to have some standardized common exceptions and orders prepared with the character limit carefully considered. Included in the materials is a checklist used in Boulder to address these issues.
Next is the permanent protection order hearing. First, ask for the return of service. If the respondent has been served but does not appear, the protection order may be made permanent by default. It is not necessary to reserve the respondent to make the protection order permanent unless you change the order, in which case the respondent must be served anew.
If the respondent appears, either party may request a continuance of up to 14 days. The court may grant this over objection upon a finding of good cause. The temporary protection order may also be continued for 1 year, but only if both parties agree.
At this stage, if continuances are not requested or granted, the respondent may either agree to have the protection order made permanent or may contest the issuance of a permanent protection order. If the respondent objects, typically you will immediately proceed to the permanent protection order hearing. The petitioner bears the burden of proof by a preponderance of the evidence that, first, the respondent has committed acts constituting grounds for the issuance of a civil protection order, and also that, unless restrained, will continue to commit such acts or acts designed to intimidate or retaliate against the protected party.
This brings us to the 5th of the top 10 complex civil protection order issues: personal jurisdiction. If the restrained party lives out of the state and service was effectuated out of the state, you will need to assess whether the court has personal jurisdiction over the respondent. This issue is more fully addressed in the accompanying outline with our materials.
As discussed previously, litigants are often self-represented. This compounds already challenging evidentiary issues and brings us to the 4th of the top 10 complex civil protection order issues: common evidentiary issues in the 21st century.
As you deal with these evidentiary issues, it is important to consider both admissibility and the preservation of the record. Text messages and social media posts are very common. Please reference the outline for practice tips.
The statute also provides for additional injunctive relief that is seldom utilized. It is important for judges to be aware of this relief, as quite often parties will be unrepresented and unaware they may request these added protections, which include both physical and financial injunctions. The court may also award temporary care and control of the children for up to 1 year. Consider using terminology in the protection order to mirror any subsequent district court order regarding children.
Often, the petitioner requests the court to prohibit the restrained party from engaging in a variety of social media applications. This raises the third of the top 10 complex civil protection order issues, the interplay of prohibitions against social media posts and the First Amendment.
It is important to consider the respondent's First Amendment rights and the character limitations on the permanent protection order when addressing the possible prohibition of social media posts.
Another important and often overlooked issue is firearms. The court shall enter orders regarding the possession of the relinquishment of firearms if the restrained party is an intimate partner, which includes spouses, former spouse, co-parents, parties who are or have been cohabitating together, which leads us to the second of the top 10 complex civil protection order issues, firearms.
Since 2013, Colorado law has allowed judges in the area of civil protection orders not only to order a prohibition of a respondent possessing a firearm, but also an order to relinquish those firearms. That basically provides an enforcement mechanism to federal law, which is often known as the Brady Handgun Violence Prevention Act. This relinquishment order can be accomplished when a court issues a protection order in a domestic abuse case. What the court needs to do is make specific findings as to the intimate relationship and whether it applies under federal law. Once this finding's been made, then the relinquishment can take place and a respondent is required to relinquish firearms within 24 hours of that order. Many judicial districts have developed forms advising the parties as to what their rights are regarding firearms, as well as protocols for the implementation of this statute. I would recommend judges talk to their judicial district and judicial officers within that district as to any forms that are used or any specific protocols that are followed. While it might seem new and novel, it's actually pretty straightforward. I've actually developed a number of materials, including a flow chart to help judicial officers understand each step of the relinquishment process.
If the protection order is made permanent, the court shall advise the respondent that any violation of the order constitutes a criminal offense and contempt of court.
On occasion, you will address motions to modify or terminate a permanent protection order. Service must be effectuated and a hearing must be held on the motion.
The restrained party must wait 2 years from the issuance of the order or the last request to modify, and the court cannot modify or dismiss the permanent protection order if the restrained party has been convicted of or pled guilty to any misdemeanor or any felony against the protected person other than the original offense. The protected party may apply to the court at any time for a modification of a protection order. The moving party bears the burden of proof by a preponderance of the evidence, and the court must consider the factors set forth in Colorado Revised Statute 13-14-108, sub 6. This has served as a summary of the most common issues you will encounter when addressing county court civil protection orders. And this leads us to number 1 of our top 10 issues. Resources. We are so very fortunate to serve as judges in the state of Colorado, as we have an extraordinarily collegial bench. If you have not already done so, ask Jennifer Mendoza to add you to the county court email listserv. If you have a question, reach out to your peers. They will help. And that, Ms. Soul, is a wrap.